Start. On the touchstone of the above said legal preposition, we have given our conscious thought on the material available on record. The genesis of the incident alleged in the FIR is altercation between the two child and thereafter reporting it to their families, and it has been proved that before a day of the incident there happened to be small marpit of the children of two families, and with the result after reporting the matter to their mothers they have also exchanged hot words. It is also established that the accused Lachman was not present at that time, and he returned from the place of his employment in the evening of that day. It is a natural fact that on coming back to home the wife of Lachman would have narrated the incident to her husband. Since the husband was not witness of the incident, the genesis of the occurrence therefore could not be presumed to know the nature of the previous incident. He might have taken a serious view and acted accordingly. Now, it can be safely concluded that it was not necessary for the prosecution to make out the motive, rather, it is very difficult to mete out as to what was the mental state of the accused. Under the facts and circumstances as stated above, the alleged motive could not be genesis of this incident by accused Lachman. On the basis of the above legal proposition on motive, the prosecution case is based on direct ocular testimony, and the ocular testimony is found to be unimpeachable and trustworthy. Due to aforesaid reasons, the argument of the defense on motive or weak motive has no relevance. Para. The last point raised by the accused appellant, that the accused has been falsely implicated in this case due to the alleged rivalry at the instance of Pradhan of the village Rajendra Singh. On this point, we would like to mention that it is an admitted fact that the village Pradhan Rajendra Singh had won the election against one Gorelal, who is said to be the near relative of the accused. It is also an admitted fact that the election was over 1 year earlier to the incident. It is relevant and important that Rajendra Singh has been produced as a prosecution witness number 4. In his entire evidence, nothing has been shown to make out a case of false implication of the accused. As early stated, the election was over 1 year before the said incident. More so, Rajendra Singh Pradhan was a winning candidate. Mere relationship of the accused with Gorelal, who was defeated in the election, cannot in ordinary course said to be the reason of false implication. Since the election had taken place 1 year back and nothing had happened in the intervening period which may suggest that Rajendra Singh was annoyed and had taken steps to harm their adversaries or to help their supporter. Para. Land Council for the appellant has further raised the point that the recovered lathi from the accused Lakshman does not have a mark of human blood. This argument in our mind has no substance because it transpires from the entire prosecution story as well as evidence tendered in respect thereof that after the incident at about 6 a.m. when the complainant tried to lodge an FIR, they were obstructed and the complainant along with the victim returned back to their house, and thereafter when the condition of the victim was seriously deteriorated, they again tried to lodge the FIR. At this juncture, accused Lakshman, along with 6 others, blocked the way, and at that time, as per prosecution story, Bharosh Hardas were said to have snatched the lathis and ballum from those accused. There appears to be a gap between the incident and the recovery of the weapons. It is not the case of the prosecution that on the pointing out of the accused Lakshman, the weapon lathi which was used in the assault had been recovered. Rather, there is a time gap between the incident and the recovery of lathi from accused Lakshman, and that too for the second incident, that is blocking of the road for going to lodge an FIR to the police station. Stop.